So we are going to be talking about courts, procedure, alternate dispute resolution, or what's known as ADR. I think it's first important to understand that there are different legal systems in the world, and it's important you know this before you go to a foreign country and assume because you're an American you have certain rights. You don't. You are subject to the laws of that country. So we have what's referred to as an adversarial system based on common law. And you'll recall, if you go back to my prior recording, Sources of American Law, one of the sources is common law, which goes way back to Roman law, but includes English common law. So a number of countries that were part of the United Kingdom uh, have the adversarial system to some degree. US, Britain, Canada, Australia, India. Most of Europe, South America, Latin America, parts of Asia have what's called a civil code system, which is not based on common law. Remember, common law court decisions. A code system is a code, a body of statutes. This is also referred to as Napoleonic law. Europe, Latin America, even Louisiana has a hybrid of common law and a civil code system. Religious law, talking, for example, Islamic countries and Sharia law. Customary law, African countries, some parts of India, China, Southeast Asia, and indigenous uh, groups in Canada, Australia. Mixed hybrid system, which combines two or more elements. As I mentioned, Louisiana is an example of that. So why do you need to know that? Do not assume you have, as an American, that if you get arrested overseas, that you have the right to remain silent or an attorney or anything like that. There's tons of examples of people that have assumed that, and that has not been the case. So there are some basic judicial requirements under the American system. Obviously, the courts don't act on their own. Somebody has to sue or prosecute somebody. There has to be a quote case or controversy end quote. That's in Article 3 of the U.S. Constitution, which is the article that is manifests judicial power. The point there being is that the courts are not going to issue advisory opinions. There has to be a legitimate case or controversy. That said, that can be set up as as a test case. You've heard of those probably. Now the big thing to understand is the concept of jurisdiction. Now jurisdiction is basically a formula where you ask yourself, is this court or does this particular court have authority over the subject of the dispute and the person or the thing being fought over? So let's talk about subject matter jurisdiction. You're talking about, it could be a contract dispute. It could be a dispute involving a government or some fundamental constitutional right, like search and seizure. So the subject is important to ascertain because that will tell you what court could hear the case. So we have that, and then the person. Remember, that person can be a natural person like you, breathing person, or a legal person like a corporation, which has essentially the same rights as you do under the Bill of Rights. And that's referred to as in personam or personal jurisdiction. It is possible that if you're fighting over a thing like maybe a piece of land or some property, personal or real, that uh, a court where that property is located could have a jurisdiction over the dispute, even if the parties, the plaintiff and defendant, live elsewhere. So there's a exclusive and concurrent jurisdiction. I'll just tell you what that means. the federal system, which I will show you a brief outline. All right, so here's an outline of the court system in Washington State, and then we'll talk about the uh, court system in the federal system. So we have a Supreme Court, a Court of Appeals, a Superior Court, and then what are called courts of limited jurisdiction, and they include county district courts, municipal courts, things like that. So that's the Washington State system. All right, this is a outline of the federal state court system. It's kind of a parallel system. As I mentioned, every state under the 10th Amendment can form their own, organize their own government, so long it's subservient to the federal U.S. Constitution. In our state, we have, as I said, Supreme Court, Court of Appeals, Superior Court, these courts of limited jurisdiction. When I say limited jurisdiction, I mean that their authority or their authority over the subject matter is limited by statute. And that epitomizes the idea of preemption, that even the courts, their jurisdiction can be and is determined by statutes, and those statutes have to be constitutional. So you have all this. Superior Court is the main court, even though its jurisdiction is limited. They can't do everything. There are some things that are exclusively federal. There are some things that are exclusively state. There are some things that you can go to either state or federal court. Let me just quickly go over the federal courts here. You have the U.S. District Court. That's the main court, although its jurisdiction is limited. And I'll tell you in a minute what that is. But you have lower courts of limited jurisdiction, like bankruptcy court or anything dealing with intellectual property, for the most part, would be a federal case. So this is the main court. Its jurisdiction is limited. There are two potential ways to get to federal court. First is called a federal question. It's if the case raises a federal issue, it can be in federal court or it can be in state court. If you file a case in state court and has a federal issue, like maybe a free speech issue involving the government, that can be what's called removed to federal court, and vice versa, remanded to state court. So you have this game going on here. But the deal with whether it's Superior Court in our state or federal court, district court, this is where trials happen. All the evidence has to be submitted in this box. And on appeal, these courts of appeals, they do not take new evidence. They are limited in reviewing what the trial court did and see if they screwed up or something happened here. But you have one right to appeal. And this is where most cases die, because the Supreme Court, whether it's state or the U.S. Supreme Court, has discretion on what to take. There are some oddball limitations on that, but for the most part, they have total discretion as to what they are going to take. All right, so as I said, federal courts, there's two ways to get their federal question. And then the other way to get there is called diversity, where the parties, the plaintiff and defendant, live within different districts, geographic districts. And that's called diversity, and there has to be at least 75,000 at issue. And I said there are states have exclusive jurisdiction over some issues like family law, things like that, state crimes, normally wills and trusts, things like that. States also have what's called a long arm statute. This is a statute which says if you do something within that state, no matter where you go, you can be hauled into court in that state. This includes things like crimes, what we're going to talk about, torts, civil wrongs like defamation, um, uh, you know, getting someone pregnant, contracts. So there's a long arm statute every state has. And so the idea of, you know, running away to another state or foreign country really is not going to prevent the state from proceeding with the case against you. Now, they have to serve you with the lawsuit. That's one thing you'll see when I talk about procedure in a little bit. The courts, state and federal, have basically rules. These are court rules, which if you're going to sue somebody or if the government's going to prosecute somebody, they have to follow those rules. And that's where things get interesting, because if they don't, that can be fatal to a lawsuit. So federal courts, exclusive jurisdiction over federal crimes, bankruptcy, intellectual property, things like that. Okay, so venue is an important concept. And again, utilize your book, the index and the glossary. If you have a book, you can also Google it. This is where you've already determined what court, like a federal court or a state court, would have authority over the subject matter, but what state court, what county, for example. And so normally it's where most of the parties reside or the action occurred, but that's an issue. So standing is another very important concept for a person to sue. Now, that when I say the word sue, I mean civil. They have to show some injury. It can't be theoretical. Again, that goes to the idea the courts aren't going to issue advisory opinion. The other two concepts are important. Ripeness, the case has to be ripe, like a fruit ready to eat, and it cannot be moot. And moot means it's over. It's somehow been resolved, or it's no longer a case in controversy. So those are two important concepts. I'll just say generally, courts are if they don't want to take a case, they are inclined to find some way to not take it. You know, standing, ripeness, mootness, all that. Those are ways for courts to avoid taking a case. So, as I mentioned, and we're going to talk further about civil and criminal law, but there are court rules that the federal courts have and state courts have governing how a civil case, proceeds through the system. When I say that, in a civil case, if you're served with a lawsuit, what I mean by that is someone hands you what's called a summons and a complaint, that starts the case. And even though they may not have filed the case, again, this can be modified by statute. Criminal cases, prosecution by the government, you would know that. Different burdens of proof. In a civil case, it's by a preponderance. The jury doesn't need to be unanimous. The objective is damages, normally money. There are things called equitable remedies, like you just want the thing you paid for, and you don't really want your money. So the criminal cases, government has to prove every element of the crime defined by statute. You have the constitutional protections, the right to remain silent, Fifth Amendment. You don't need to testify. In theory, that can't be used against you. There's a whole bunch of reasons why in the criminal world, those accused of crimes do not testify, because then it opens up a Pandora's box for questioning. So, all right. So you have these parallel court systems, federal, state, even local, municipal courts. They have their own rules too. I've mentioned original and appellate jurisdiction. Now, again, you go back to that chart in the state of Washington, the main court is the Superior Court for the county. In the federal system, it's the U.S. District Court. Every state has at least one. We have two in the state of Washington, Western and Eastern District, where the main action takes place. Appellate courts, again, no new evidence. They just review what happened at trial. So it's important at trial that the objections be made and all that stuff. So alternative dispute resolution. Okay, this is a very important way to avoid court. That's why they call it alternative dispute resolution. It's an alternative to litigation. Very, very common in contracts, employment contracts, for example. But examples of ADR are negotiation, mediation, arbitration. Now, what's interesting about ADR is that this is private. It's not public unless there's some statute that mandates it. But these are a way to resolve a dispute privately without going to court, which is public, and resolve the problem. Whoever is in control, like the employer, has a lot of discretion on what to utilize as part of ADR and who to hire as a arbitrator. All right, so that is a quick review of courts, procedures, and alternative dispute resolution. I hope you found it interesting.